Well, hello, friends, and welcome to Uncivil Law, where we learn through the misfortunes of others. And with respect to Kyle Rittenhouse's future in his trial, things continue to go poorly. The fact that it goes poorly seems to be the collective consensus of the internet YouTube commentariat. Nick Rikita, Good Logic, Emily D. Baker, me, who else is in this pool? The guy from South Korea whose name temporarily escapes me, with the cat snazzy suit. He's good too. He's on the page. Robert Barnes. The collective consensus appears to be it is not going well. Things are going poorly. They're the only division of opinion at this point is how bad is it, which is not really the question you want to be asking. Right? So like, how bad is it? If that's the question you're debating over, things are not going great. So yeah, things are not going well. The problems that were manifest yesterday continue to be manifest today and are more evident today. Yesterday's cross-examination, we only really saw the one, which was the friend who bought the gun. That was a pretty good cross-examination. I said so at the time. It was good. There was nothing really objectionably wrong about it. It might have been a little bit tighter, but it was solid, and he got good points out of it. So yesterday's cross-examination gave you some hope. The opening statement continues to be trash, but yesterday's cross-examination gave you hope. And then we didn't see the cross-examination for the FBI witness, because it wasn't on tape, and we didn't see the cross-examination of the social media guy because yesterday we hadn't gone that far yet. So today we got that far, and things went from bad to worse. The lead attorney for Rittenhouse, he's bad as a trial advocate. It seems apparent to me that he apparently has taken no trial advocacy courses. He seems to be missing some fairly basic stuff. And it's damn sure he hasn't even taken something like Toastmasters, where in the basic manual, before you get to more advanced stuff, because I'm a Toastmaster and have been for many years, you learn things like vocal variety, you learn things like visual aids, you learn things like outlining your argument, basic kind of speech skills that is not present in this guy. Robert Barnes is of the opinion that this guy is a very good factual guy. He remembers the facts in his head. Okay, I'll take his word for it. His advocacy, no. He continues to just flub around the page. It's the same problems yesterday, and more so. He can't tell a story. Yesterday I talked about the importance of story. I'm not going to regale you with that. You can see that again. Yeah, you can see that from yesterday, where I talked about the importance of a story. It remains important today. He has no story that he's trying to tell through the cross-examination. There doesn't seem to be any narrative to the questions he's asking. He seems to be asking a lot of questions that don't seem like they could have relevant impact to him. There's like preliminary questions to set the foundation, but you don't really need that because the preliminary foundations to set the foundation were done indirect. So you don't really need to do it again unless you're having some specific purpose, and that purpose was not apparent. He scored some good points. He got some good points out for Rittenhouse, so it's not like it was a complete shit show, that nothing good happened, but those moments, those highlights, were so far and few between in the overall drudgery of the thing that it's quite possible the jury just simply missed them because he is boring the jury to death. If he's boring me, this was also the consensus from the panel today. If he's Attorney Tom also was on that panel. He has also the collective consensus things are not going well. If it's boring us, it's boring the jury. So these good points that he's getting out, we have no ability to rely. The jury is hearing it. That's how well it's going. It's not going well. So it's a problem. It's bad. There's no story. The there's nothing keeping the jury together. Now, this isn't, of course, to say the prosecution is doing everything right either. The reason the prosecution called the social media expert continues to be a baffling mystery. And also that examination went on forever. I think it went on for 6 hours between yesterday and today. And why? I don't think he said anything of any value during the entire 6 hours. And unless I'm mistaken, but I'm pretty sure I'm not, there was a direct, a cross, a redirect, and a recross. It went on forever. It just wouldn't end. It wouldn't die. I was dying, but it wasn't dying. Finally, mercifully, it came to an end to save us all. But it remains a mystery why he was called. Now, Robert Barnes is of the opinion that he was called specifically to bore the jury, because he has these visuals of these videos, and so maybe the idea is to bore the jury to death and also to bore them of the videos, which I don't know is strictly speaking necessary, because I think the defense lawyer accomplished that objective just fine in his opening. But maybe that was the idea. It's certainly a coherent one. Maybe that was what he was going for. If his goal was to bore the jury and to make them stop caring about things, mission accomplished. But I think the defense was already there, so it seemed a little unnecessary. So yeah, it's not going well. There is no reason now. Is it salvageable? Yes, it's not like it's game over, but things are not going well. I shouldn't have to tell you. Well, here's something else Robert Barnes said. This was said last night on the stream with Nick Rekieta, because I listened to part of it. He said that he did some polling in Kenosha or whatever, and he said, if I'm quoting his numbers correctly, like 64, 65%, something like that, had a preliminary decision of guilt. So the random jury pool was, roughly speaking, 2/3 of the opinion that Kyle was guilty, which is not great going in. So you can obviously fix that to some degree in jury voir dire. The degree to which they did fix that in jury voir dire, who knows? Because I don't have enough information to say whether or not they were able to fix the problem in jury voir dire. So one can only hope with bated breath that they were able to fix the problem. Although there's no reason to have that particular confidence. But yeah, if your random jury pool is 2/3, you have to account for the probability you won't be able to get all the people biased against you off. And so you have to convince those people, and you're doing nothing to help. So it's bad. It's bad. And I shouldn't have to tell anyone about the importance of making a good first impression. The jury, it has been suggested by Robert Barnes again, if I understood Robert Barnes correctly, it's been suggested by Robert Barnes that the jury has a pretty high percentage of making up their mind by the end of opening argument, which sounds very plausible to me. So I have no reason to particularly doubt that. It sounds right. And even if Robert Barnes is off, by that idea of the opening argument, the first 2 days in totality would do nothing to correct that impression. So will something happen in the next couple days that will somehow change this impression? Seems unlikely. We have no reason to believe it. We have no evidence that would allow us to draw this conclusion. The only way it gets any better is if the other lawyer takes over. That would help a lot. I can't get any worse. I could go there and I could do not worse. As the chat in Nick Rekieta's chat pointed out, though, their dogs could probably go in and do not worse. So it's not a very high standard. But yeah, I think, and also it was interesting today because the chat in Nick Rekieta's chat came out to the collective consensus that, oh yeah, story is important. So the trolls from yesterday who are like, story doesn't matter, you're a dipshit, or the collective consensus was today, story matters and this guy blows. So that was a bit validating, I won't lie. All that good stuff. So is there any reason to suspect that during the government's case in chief, so while the government is the one calling witnesses, is there any reason to suspect that it's going to improve for the defense? And the answer to that question is no. Why would it? The prosecution's making some missteps. He's not perfect. He's a lot better than the defense lawyer, though. And if you already have the bias going in, which seems to be present, the prosecution doesn't have to do as much heavy lifting. And he's giving a cohesive narrative that a jury could buy. So there's no reason to expect it's going to get any worse for the prosecutor. He will probably make similar missteps in the future, based on relative 2 days, make some mistakes, call some witnesses that seem questionable, make some tactical decisions that might seem questionable, but we can expect roughly the same performance, one would imagine, and likewise from Kyle's side, once again, unless he gets replaced. So it's all those things. So Mike Gee says, I love your holier than thou storytelling attitude. I don't know if I'm holier than thou. It's just better. I feel like I'm more competent as a trial advocate because I've had public speaking skills in Toastmasters and know how to structure and organize speech. A lot of this is off the cuff, which incidentally has been helped by my improv classes. But in structured speeches, I'm pretty good. I've won some regional competitions before in Toastmasters in structured speeches. So I know how to write a good structured speech with vocal variety and pacing and how to use body movement and all that good stuff. It's, trying to bring that into the on-the-cuff stuff is not been as easy a transition, but whatever, it doesn't matter. Anyways, so then you have to ask, okay, so how will things deal with when the defense takes over? When the defense starts calling witnesses, maybe that will be their strength. The reason maybe it will be their strength is the reason that direct examination is better for both sides. When you're doing direct examination, you can script the entire direct examination. You can literally write every single question down. And you can literally go over with your witnesses every single question in the order that you're going to do it. And you can help to prep them without coaching them, which can be a bit of a fine line. But the biggest thing that separates it is obviously you can't tell them to lie or withhold critical information, but you can basically help them present the information in a way that would be less detrimental while still relaying it. So that's one kind of the distinction you can keep in your mind. So one of the reasons direct is nice is because you could literally script every single question with a thematic element and go over the witness with every single question and know every single answer in order to tell a story. You could do that. Now, that doesn't necessarily mean that you'll get the answer at trial that you want from every single question. Because the idea that no matter how hard you prep your witness, that they might say something on the stand that you didn't go over in rehearsals, basically, is not exactly unprecedented. But you make it as good as you can. So the surprises, to the extent they exist, are hopefully very minimal and are very containable. So maybe it's the case that he's able to write this direct examination in a very coherent way that will tell a story that will be better. One can only hope. We have no reason to believe that from the evidence we have, but it is a different skill set. Maybe someone else will ask questions on direct. That would help a lot too. So there is reasons to hope, at least, that things could get better when the defense starts calling its witnesses. It can't get much worse from here. So, but there's a lot of damage to undo. There's a lot of mitigation work that has to be done in part 2. So it's not like it's impossible. It's just that, as the stream title says, we're kind of pretty FUBAR'd. And we're not totally FUBAR'd yet, but things are not looking promising in the FUBAR direction. And as the days go on, and as the prosecution's case goes on, the more this repeats, which we have every reason to expect it will, the more and more cemented the bad will come. So you're looking for a pretty Herculean effort to undo all that damage, which is possible, but not trivial. And as I said in my description, it should not have been this way. It should not have been this way. The defense's ability to tell a good story was present from the videos. We've all seen the videos. We've analyzed the videos. I've discussed them before on my channel many, many times. I've been of the opinion that he has a pretty rock solid defense case for self-defense. Looks pretty good to me based on the videos. So it should be a relatively easy endeavor, although not totally easy, but easier. It should be a much easier endeavor to construct that narrative than, say, for the prosecution, because the prosecution has less to work with. They've constructed a narrative, perhaps the best they can, given what they have to work with. The best they can still is not very good in a total sense, because the facts don't allow for anything better. The defense had the facts that would support a narrative that would be incredibly strong. We've seen the videos. We've all seen the videos. We've analyzed the videos in depth, frame by frame, between my channel, Nate's channel, other things. It shouldn't be this way. The defense should be basically walking this. It should be a walk in the park. How they're able to screw this up remains a thing of wonder. How the defense is able to use these videos, which should be amazingly good for Kyle, how they're able to use them and make it so that no one cares because it's so boring, monotonous, and mind and soul sucking is a thing of disturbing beauty. It's like, how are they able to turn this beautiful, well-arranged thing into this, like, this flower of death? How are they able to take this growing rose, which was blooming into a champion for the garden show, and turn it into this absolute trash fire of a rose at the end? It's truly a thing to behold with negative wonder and absolute amazement of the ability to turn gold into shit. Usually you try to do the other way around. You usually try to turn lead into gold. These guys that managed to turn gold into lead, I'm not sure they fully understood the alchemy idea. They kind of go in the wrong direction on that one. $5 from Provolone Loaf. Doom posting sucks, but when every law tuber is saying it, good lord. Yeah. Never gone to any protest, day or night. Feels bad, man. Thanks for the coverage. Yeah, I want to emphasize again that I'm not necessarily saying that we're all doom pilling to the same degree. But even the most optimistic of us, I think, are hoping more than believing, I think. Because we want it to be true, and surely we'll be able to pull this out of the shit storm that it's in. So, all the good times. So let me now answer some questions that I've answered and sufficiently doom-pulled you all. Again, if you want to ask a question, all you have to do is start your chat with either the word question or the @Uncivil Law, and it will pop up in my bot, and I will notice, and I will answer your question. Here's the questions you've had so far. Natsuro says, Nick says it's still bad but salvageable. Nick is technically right. It is salvageable. We're trying to assess the probability of it being savaged based on what we know so far. So, sure, we could pull a rabbit out of the hat, but unfortunately, if you're casting odds, let me put it to you this way. It is salvageable in the sense that it's winnable, but if you were taking odds as a bookie, I don't think you would predicting its salvageability as the most likely conclusion. How unlikely it is the bit of dispute. Is it 3-1, 4-1, 5-1, 10-1? How bad is it? That's the only dispute we're really having. Tony D says, didn't Barnes talk up Mark Richards before the trial? I don't know, and if he did, which wouldn't surprise me, this would be probably during the period at which he was on the team. So when he was on the team, which he isn't anymore in any capacity, he clarified that last night. So at this moment, he does not represent Kyle Rittenhouse in any capacity, criminal or civil. That's all over for the moment. But when he did represent him, you can't go out there and badmouth a member of your own team. That doesn't make any sense. So did he say good stuff? Sure. Wouldn't you expect him to? Of course. So I'm not sure that you can necessarily take that for any other way. Scorpion 142 said Kyle started with a downhill battle. Richards make it an uphill one. Yeah, something like that. Maybe the other way around, but yes, it started with him just being able to roll down the hill, I guess, to use your analogy, and now we have to do the Sisyphean task of pushing the boulder up the hill. $5 from Her Excellency. Did you see Kyle having to help them out with the computer? I wanted to pull my hair out, poor kid. It was unclear to me if he was helping them with the computer as such, or if what I saw or what I interpreted it to be, and it could be what you saw. So maybe he was trying to help them with the computer in a technical sense. But what seemed to me was actually going on, which is even worse, is that the defense lawyers didn't know where in the video or videos they needed to go to find this specific thing. So it seemed to me they were asking, hey, Kyle, by the way, do you know where in the videos this piece of evidence is? And it seemed like Kyle was saying, here's what it is. And the fact that he knows it and his own defense lawyers do, if that's what's happening, I'm not sure which is the better. Yes, I'm actually sure which is the better interpretation. That they were failing technically is the better interpretation. That they were failing to know where their own evidence is definitely the worst. But that was the way I parsed it. So take your pick. Grimm's Bar said, could the defense go through the files they got from the defense? You mean the prosecution, presumably. And look for the video that had militia in the title. If the video doesn't say militia, they definitely didn't follow the law. That is not true. If that doesn't even make sense. If the video doesn't say militia, then he definitely didn't follow the law. I don't know what you're trying to say, but that doesn't make sense. I'm not sure that a video has to be titled and or use the word militia to trigger a law. And no. MK Perez says Barnes was seemingly right on Richards being unable to construct a communicated narrative. Well, yeah. I mean, I can see that with my own damn eyes. Graham's Bar says by not handing over all evidence and tampering with evidence. If you're referring to the Fleur video about not handing it over, that does raise Brady issues. Tampering with evidence, it's unclear if it's been tampered with. It was obviously marked by somebody, but whether or not the originals were presented to the defense is unclear. So the ones we've seen in trial are the ones with, scripts on them and stuff like that. But whether that was the only version presented to the defense or whether the defense was presented with raw versions without those annotations is unclear. Scorpion 142 says, can Richards come back tomorrow and move to strike the witness and evidence? No, it's too late. He could have moved to strike the social media guy at the end of that testimony or before he did a cross as irrelevant, but it's too late. You can't just move to strike because things are not going well for you. No. Wolfgang Winter, what was your take on what Robert Barnes says about the defense team? I have no reason to contradict what he said about the defense team. And I have no reason to contradict. I mean, he was there factually, which is a slightly different posture than other issues where I've had a disagreement with Robert Barnes, right? In other areas where I've had a disagreement with Robert, it wasn't like he was there in the sense of being a lawyer involved in those cases where we're discussing. We were both approaching them from an outsider's point of view. So those were the disagreements. Here, he's a factual expert because he was there. He had the ability to observe these people. He had the ability to see what these people is. So I have no particular reason to contradict his observations. I have nothing else to contradict them with. So sure, that makes sense to me. And it seemed plausible. So sure. Charles H. says, do you think they'll put Kyle on the stand? That seems to be what they were saying. Any pros to putting him on the stand? It's hyper risky. The only way for it to really make sense is for Kyle to basically lift this entire load. So Kyle has to actually be the one to tell the story himself, which shouldn't be his job because the defense lawyer should have done it for him. And exposes him to cross-examination. And it's basically borderline impossible to imagine that the prosecution during cross-examination of Kyle won't be able to get Kyle to say something that in isolation will be damning, which they will, blow up to 140 font and, display to the jury. It is borderline impossible that Kyle will be able to give his testimony without saying something that sounds incriminating in isolation, especially once he's cross-examined. A good lawyer should be able to extract something, anything, a thing that can discredit the witness, which to the defense lawyer's limited credit, he has been able to do with respect to every witness he's done. He has done that. It's been buried as shit, but he's done it. So the idea that Kyle Rittenhouse, especially, this is not really an issue of sophistication. It doesn't really matter how old you are, but him being younger isn't helping. The idea that he's going to be able, because he has to go toe to toe. This is like talking to the police, by the way. It's the same problem. You're having to go toe to toe with a person who's an experienced professional in an interrogation, which, that's what direct examination is. It's like questions and answers, right? And you have to go toe to toe with a guy who's been doing this for a lot of years without saying anything that can be used against you. This is not going to happen whether you're talking about the police or you're talking about the DA. Basically, the only thing us lawyers are betting is how long it's going to take before you say something stupid. So that's the problem. The risk is Kyle will, for absolutely a certainty, say something that will be damning in some isolation and will be used by the prosecution. You heard it come from his very own mouth, where he said excerpt phrase that without context sounds really, really bad. So forth and so on. This is the problem. Peter George says, today the judge will talk about specific people on cable news and how they're covering the case. That seemed really odd to me. Any comment on that? I didn't see that portion. I wasn't there for the whole time, so I won't comment on that specific thing. I was in and out, so I didn't see that specific discussion. Tom Forsythe said, is the representation so bad he could get an ineffective counsel appeal? I'll tell you what, my friends, we're on the road to an ineffective counsel. But the standard for ineffective counsel is pretty high. He's not drunk. He's not sleeping. These things, incidentally, have happened in prior cases. Right? So he's not drunk or high. He's not sleeping. He's lucid. And the questions you ask are tactical considerations. This is the lawyer's role. The client says what they want. The lawyer says how to get there. So the client says what they want. In this case, not guilty. That's what the client wants. The lawyer's province is to do everything to get there. So every question and narrative, everything that they do is a tactical / strategic decision. So the fact that those tactical strategic decisions did not pan out is not in and of itself sufficient. But there's been so many of them that I think you're on the road to getting there, but I'm not sure you're there yet. In fact, I'd have to recommend against it. Although at this point, it's probably the only viable appeal you have, to be quite honest. Unless he's convicted on, for example, the possession charge, which you have some legal arguments for why that's not valid. But you can't overturn the case based on lack of evidence. The prosecution has sufficient evidence to convict. The question there, by the way, is whether a reasonable jury could conclude the jury has the ability to believe and disbelieve evidence. That's one of the things juries do, and also weight the evidence. So a jury can believe or disbelieve a witness's testimony in whole or part. They can also assign weight to parts of their testimony in whole or part, and weight to different testimonies in whole or part. So the jury gets to determine what's true, So the only way for you to say there's insufficient evidence is basically that the weight of the evidence is so massive the other way that no reasonable jury could have possibly drawn these conclusions. But we're not there. We're not even close to there, and I'm not sure we're getting there. So ineffective assistance of counsel is your best bet, and even that, I wouldn't bank on it. Rick Dalton says, if Kyle were to lose this case, it would mean self-defense is unobtainable right in any self-defense case across the United States. That's just not true, Rick. If Kyle loses this case, it does not mean that no one can win a self-defense case. It means that his lawyers were really shitty. And don't hire shitty lawyers. Jake Lyons says, what do you think about his friend and his own trial getting delayed so he can testify? The prosecutor called him out, and then the defense pounced on that. I mean, his friend is apparently guilty of some various crimes. The fact the trial is being delayed makes sense, so he won't be a convicted felon. So if you try him in advance, he's a convicted felon, which obviously more heavily weights on his credibility. So the fact that the charges are only pending is slightly better. So it makes sense. But it's hard to believe that he's not getting some kind of a wink, wink, nudge, nudge deal of some variety. Uncivil law. Barnes couldn't badmouth the other lawyer, especially when he's on the same team he can't. But he says that only recently did he ask to see the fund's legal paper. He said he was given assurances when he started. Why not check? That's a very good question. I don't know why he didn't check. And at this point, because by his own admission, he's not representing Kyle in any capacity. He has no right to the paper. He's just a guy at this point. Provo and Love says, extremely speculative, but do you think Bringer is eyeing running for office if he gets a full slate of guilty? Well, I don't know if he's eyeing it or not, but this will certainly help. I mean, you can't deny that. Bitches the Third says, what do you think Juror 7 said to the guard? I don't know, and they'll get into that tomorrow. I'm sure it was just something very off the cuff. If I were a betting man, it's something probably pretty off the cuff and pretty non-suggestive. But anytime a juror comes in contact with any member of the staff, they have to have an inquiry about it. So I assume it's not going to go anywhere, but maybe they said something more suggestive. We'll find out tomorrow. If the video doesn't say militia in the title, then it's not the same file technically. Therefore, all the evidence was not handed over. I don't know that's true. It would mean the file had been renamed, I guess, but I don't know. I'm going to pass on that one. Scorpion 142 says, in regards to the video title, the judge said Bringer couldn't call Kyle a part of the militia without proof. The current video does not have militia. Bringer's video did. Was that a video? Who made that video? Would be my first question. Because just because some other random person called Kyle militia doesn't seem that helpful. If Kyle made the video, but I'm under the understanding that Kyle didn't make any videos that night. So I'm not sure how that video having the militia in it or not would be proof. It's, yeah. Joseph House said, question, when do you think the case should have been dismissed with the content of the video? I think the case should have never been brought. The self-defense is an affirmative defense, and the state, at least at the beginning, seemed like they had a pretty insurmountable level to get there, but I guess it shows that the judge was right not to dismiss it, because the only way you would dismiss it is if the prosecution can't get to where they want to be. So the judge apparently made the right decision, because thanks largely in part to the defense being borderline incompetent as a trial advocate, they are able to get to where they want to be and are even likely to get to where they want to be. You know, it is, in my humble opinion, more probable than not, which is not reasonable doubt, but we're well on our way. We're heading in the wrong direction. Jake Lyon says, Uncivil Law, what do you think about the FBI and then possibly intimidating jurors without actually intimidating them? I don't know what you mean by the last part. As to the FBI, I commented, I believe yesterday when we discussed it, that things look a little sus. Things look a little sus with the FBI, but it's hard to tell for sure because I don't have the transcripts and I don't have the audio. So I'm basing it off secondhand news reports, which I'm not going to trust implicitly because why would I do that? Why would I trust secondhand news reports implicitly from the media? So the news reports that I have seen, which are automatically worthy of skepticism, suggest that the FBI guy is a little sus. So that's as far as I'm willing to go. The FBI guy is a little sus, based on the outside observation. Things don't seem like they might be quite right in the state of Denmark. 420 Atheism says, can we assume sabotage from the defense if they put him on the stand? No, I don't think you can assume that. You can just assume that they're stupid. Stupidity is always a possible explanation. It's hard to believe the lawyers are this bad, but yeah. Philip Coggin says, what's the reason not to object when he could have? Do you think those videos could have helped Kyle? Yeah, I'm not as critical of this aspect as some of the other lawyers are. This is largely in part, incidentally, because I'm so critical of the story and narrative that for me, the failure to object is such a secondary issue that I've kind of pushed it out of my mind. That's how bad the narrative and story issues are. That's how bad the presentation aspects are. The vocal variety, the pacing, the presentation, the use of evidence, the use of visual evidences, the questions asked, right? That is so bad that I've basically pushed the issue of whether his failure to object is a problem or not. But yeah, some of the other lawyers have focused that on more of a problem. So let's discuss that a little bit. Is it bad not to object in general? Okay, let me rephrase. If you can object, should you object? The answer is not necessarily yes. Objecting too frequently can make you seem bad to the jury. But here's the thing. Every time an objection is sustained, the jury can't hear something. And the jury wants to hear the thing. They want to hear all the things. That's why they're there. And so you, the defense lawyer, have interjected yourself to prevent them from hearing a thing, right? So this is a cost-benefit analysis. So the question becomes, how important is it? Or how much should I let slide? From a position of advocacy, from a position of, should I object to this or not? Is it worthy of an objection? Incidentally, we saw this failure to consider this from the prosecution during the defense's opening argument. When the prosecution objected to the defense's opening argument, they ran into the same problem for exactly the same reason. It's like you're denying them the ability to hear the story. And also, particularly, it's Dick to do it in opening, which didn't help. So that's a point for them. But yeah, this is why you have to be a little bit careful on your objections. Now, the defense has basically, have they raised any objections at this point? I'm not 100% sure if they have. So it might have gone way too far the other direction. And there might be issues with the videos and things that are not being raised that really should have. So I'm not hypercritical of the failure to raise objections in general, but whether or not it's gone well past the band or whether or not there were objections that were so worthy of the cost-benefit trade-off, right? Because you take a little bit of a bite, but if they hear really bad evidence, that's more of a bite, right? So is there situations where the cost-benefit is so clear they should have objected? I'm just going to assume it's yes, because that's how it's going. It's just not something I've been particularly focused on, mostly because he's boring me, and I'm having literal problems paying attention to him. I am not retaining everything he's saying. I don't think this is a me problem. So did he fail to object? I'm like, what? Huh? What? It's like, it's not helping. 420 atheism. Can a judge rule a defendant not guilty in lieu of a jury verdict if he believes the defendant's clearly innocent? Yes, he can. He can do this at one of two places. He can do this at the conclusion of the state's case, in which case it's called a judgment as a matter of law, or he can do it after the jury comes back with a verdict, which is called a judgment notwithstanding a verdict. This, incidentally, is the distinction between a judgment and a verdict. The jury comes back with a verdict, but only the judge comes back with a judgment, right? So the judge's the verdict might be guilty, and then the judgment is, how about not guilty? Incidentally, you can only go one way, right? If the jury finds you not guilty, you can't go the other way because, Constitution, which is, thank God for that. But yes, he can do that. Will he do that here? No. It seems. Let me put it to you this way: I consider myself very pro Rittenhouse, but simultaneously, if I were the judge in this case, I need to put aside my own personal beliefs, and I need to assess it as a judge would assess it, which is often what I do on this channel. How would a judge assess it? So, would I, as a judge, grant a judgment as a matter of law, or a JNOV, judgment notwithstanding the verdict, based on what we know right now? No. Unfortunately, once again, the prosecution has made its burden. It is possible now for a jury to reach the conclusion of guilty based on the evidence that's presented, mostly because the defense's case has been horrible. So if you came to judge Uncivil law with the I want to not have this case go to the jury, or I want to overrule the jury, no. I really wish I could, but in this hypothetical example where I'm a judge, I do have canons of ethics that apply. I have rules that I have to follow. I can't just do anything I want for the hell of it. This is incidentally one of the reasons that a good judge is a good judge. As Scalia once pointed out, a good judge should not be, it's a bad sign if a judge always reaches the decision he wants to reach. It's a sign of a good judge if he reaches decisions he doesn't want to reach. That's a sign of a good judge. The law compels this result. I don't want it. I think it's crap. I wish I could do something else, but I can't. The law demands it. So I wanting to be a good judge, even though I'm Team Rittenhouse, I would unfortunately, at this point, have no choice but to send Kyle to jail if that is the conclusion the jury ultimately comes back with. I'm sorry. Please don't consider me the traitor. It's the law. I can only do so much. I'm really, really sorry, but that's where we are. King of Casual says he can just hire Barnes. That would be helpful. Alexander Harper says, question, could ineffective assistance of counsel making prosecution's point help appeal if needed? Oh, sure. There's lots of things that you can argue ineffective assistance of counsel. As I said, we're well there. However, ineffective assistance of counsel in criminal cases in particular, is a pretty high bar. So your typical go-tos are like utter negligence of not doing something, like utter negligence of not following up on a witness, utter negligence of, not following up on prospective lines of inquiry, being drunk, falling asleep, being high. Ineffective assistance of counsel takes a lot. Being a bad lawyer is not ineffective assistance of counsel. So he's on the way, and yeah, that's a decision for the Court of Appeals. But at least as a trial lawyer, I wouldn't be getting there. So, Miss M.K. Perez says, why they seemingly stipulate to the entry of any and all these videos without the people who made them explaining them? That's a really good question, M.K. Perez. There is a strategy to be had. I'm not sure why it was employed in this example. I don't know the answer to that question. That does seem strange to me, too. The King of Casual says, Rittenhouse should have been delayed for a pardon. We vote red more than blue. A pardon is also possible. That, of course, is a political remedy more than a legal remedy. But, yeah, of course, the governor, I don't know if the governor can do this in Wisconsin or not, because some states the governor doesn't have the power, and some states they do. Some states it has to go through a board, blah, 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 whatever. So I don't know if it's possible for the governor to do that or not, but Sure, the governor could, but of course that comes with massive political consequences, and probably I wouldn't bank on it. Incidentally, in case you're wondering, the president cannot pardon because this is not a federal crime. It would have to come from some state authority. State 142 says that the failure to object is a problem when the evidence is being shown is not yet admitted, and Binninger is narrating. Fair. With the addition of completely irrelevant witnesses to the evidence. Yeah, that did seem to be fair, and this objection was re-raised at the end of today and will be re-argued tomorrow as well. So there's a question at this point of whether the defense preserved the objection. You have to object at the time. You can't just object later when you realize, I should have, you have to object contemporaneously. So there's a question of whether or not the defense preserved the objection. It seems on initial inspection they did. And so if they preserve the objection, the judge can reevaluate it. So there seems to be there's going to be argument on it tomorrow. So that issue is not yet completely resolved at this point. One question. I read an article saying the trial could last 3 weeks. I heard 2, but whatever. If it's a long duration, is that worse for Kyle? In so much as it gives the prosecution more chance to cement his fate, then yeah. I mean, if the prosecution only had 1 day versus the prosecution has, 2 weeks, then, the cumulative effect of 2 weeks will almost certainly have to be greater than the 1 day. So that's bad for that reason. Jason House said, I believe the content of the militia doctor video was that submitted should have been thrown out, as I believe it was editorial of the original video. Fair. If that title was displayed to the jury and that was not part of the original, then you're correct. That you're correct. They can't rename it for that purpose. So if that's what happened, and they timely objected to that for that reason, that would be a valid objection. You'd be correct in that case. Proctor Hawk, great name by the way. Proctor Hawk, I'll say back ex post. Oh, no, I'm sorry, wrong one. I'll say back ergo Proctor Hawk. No, that's you. Post Hawk. Yeah, Proctor Hawk, the response is Post Hawk. I got there eventually. Uncivil Law says, how damning could this precedent be for future cases? It will not have any effect in future cases. The reason that Kyle Rittenhouse is losing is not on the law. If Kyle Rittenhouse goes down in flames, it has no impact on future cases. A better defense lawyer will be able, assuming we have Kyle Rittenhouse 2.0 in some other person, a competent lawyer will be able to raise every defense that this lawyer should have raised. It will not have any preclusive effect. The only way it would be preclusive is if there's a legal change, which can only come from the Court of Appeals, and there's no reason to suspect that at this point. So Kyle being screwed over only screws over Kyle if it makes you feel better. Jim Salata says, I'd rather them use this than the Dershowitz plan from OJ trial, challenging everything and making them work for admission of every piece of evidence. This is a very valid point, right? Yeah. Challenging everything and making them work for the admission of everything can be very problematic to the jury. So that is probably ill-advised in my opinion. And it's also ill-advised to object to nothing. There is a balance, and those are tactical considerations. But yeah, Dershowitz's plan, even though OJ ultimately got freed, so it ultimately didn't hurt. Well, it's not fair to say it didn't hurt him. We don't know if it did or did not hurt him. We just don't know that it didn't change the ultimate result. But whether it changed the margins on the result, we don't know. So yeah, it's ill-advised in my view. By the way, if you're looking for someone to read on good trial advocacy, Jerry Spence is your guy. Jerry Spence is the most notable trial advocate of our time. He's well-renowned. He's written many books on trial advocacy. So if you're interested in how to be a good trial advocate, and Jerry Spence's books are very readable. Jerry Spence is the guy you want to read. Go read his stuff. It will help you a lot. I'm guessing that our defense lawyer friend has not read a Jerry Spence book. Yeah. With regards to the gun charge, is the judge likely to make a judgment as a matter of law? No, he's not. Well, you're asking the question slightly wrong. So I answered your question the way you literally wrote it, but I'll rephrase it. So is the judge likely to throw out the charge? That's very possible. Which isn't quite the same thing as what you asked, but I know it's a technical distinction. So I won't give you a hard time. But is it possible or likely the judge will throw out the gun possession charge? Yes, that is a thing that could happen. Leon's Law says governor is Democrat, so he's boned. But even if he's a Republican, it doesn't necessarily mean anything because of political issues. Is it possible a judge could set aside verdicts or give a directed verdict on some of the charges? Yes, absolutely. Every charge is just in the same way the jury can come back with different verdicts. There's nothing precluding the jury from coming back not guilty on some charges and guilty on other charges. And this is also a little fun aspect of U.S. Supreme Court law. Even if those are inconsistent. Even if they're inconsistent. So a jury can come back with verdicts that are inconsistent. In other words, there's no possible way both these verdicts could be correct. But the law says, because the thing is we don't know legally which one was wrong. Right? Because the only way this happens is if they come back with a guilty and a not guilty. Right? Because if they come back with mutually guilty verdicts, well, I guess that's strictly speaking, well, yeah, if they come back with mutually guilty verdicts or mutually non-guilty verdicts, I don't think it can happen. The only way it can happen is if they come back with a guilty and a non-guilty that would contradict each other. But the thing is, the Supreme Court has ruled, and it's been ruled a couple different ways on this question. The Supreme Court has ruled that it's not necessarily the jury made a mistake. Maybe they made a compromise amongst themselves as part of the jury deliberation process. So they decided to split the baby Solomon style, which, okay, maybe that's what they decided to do. So sure, why not? Mutually inconsistent verdicts, no problem. Could the judge also set aside verdicts one at a time? Sure. They're each considerable unto themselves, no problem. I'm not expecting that to happen at this point. As a layman, I came away with the feeling the prosecutor was pseudo-testifying. No, your view? Yeah, especially with social media guy, for sure. For sure, he was pseudo-testifying. He was having to lead that guy to water. Woof. Again, why this guy was called is beyond comprehension, but the prosecutor was testifying. I don't understand why the defense didn't object to this witness, didn't object to his relevance, didn't ask for him to be struck. The whole thing was mind-altering, bewildered. But yeah, the prosecution was definitely crossing the line in direct. You can't feed. Okay, it's actually technically a leading question, incidentally. What defines a leading question is when the question suggests the answer. So it's not a yes-no question. So, which is often what some people think. So some people think a leading question is a yes-no. So, did you go to the park? Is that leading? No. Why? Because it doesn't suggest the answer. Did you go to the park is an open-ended question. It's an open-ended question that has only two possible responses, yes or no, but it doesn't suggest which of those is correct. So, yes-no questions are not leading. What is leading is when you suggest the answer. For example, you went to the park, correct? That suggests the answer is yes. So you can't phrase it that way. So not only was he feeding him, he's technically asking many, very, very leading questions. So yeah. King of Casual says, this makes me sad to be a Wisconsin resident. It makes me sad to not be a Wisconsin resident. Kyle Rittenhouse was supposed to have this in the bag, man. It was supposed to have it in the bag. It was supposed to be assured. How are we at this point, man? Automata says, Kyle being screwed over may only impact Kyle legally, but there's a societal impact of chilling people's use of self-defense or defense of property. That's also possible, I guess. So, sure. Point noted. Propter Hawk says, I appreciate the clarification. Not too many people catch my username. Kudos on that. Cheers, man. You're welcome. After that, therefore, because of it. Scorpio 142 says, thank you very much for answering these questions with slight ideations to make them accurate. I always try to correct myself if I make mistakes. And if someone in chat points out a mistake, I always try to correct the mistake. Because I'm a good legal educator. Sometimes I make mistakes when I say things. If I notice them, I correct them. If the chat notices them, I correct them. That's probably what a good educator should do. No problem. You're welcome. Cody Sam says, I missed the powered hour. Mind giving me the Bridges version? Sure. Kyle Rittenhouse is basically all but ready to be dragged out behind the courthouse and be shot. That's where we're at. Alexander Harper says, question, what are the chances that the defense getting the prosecution to object on Crasudo videos already shown on direct? Oh, zero. Zero. The prosecution literally can't object. If the prosecute, you can't do that. If it's admissible by one side, it's necessarily admissible by both sides. So if the prosecution introduces a piece of evidence, if the defense offers the exact same piece of evidence, the prosecution literally can't object to it. It's not possible. It's already been admitted. You can't object to its admission. It's been admitted. That's done now. So there is zero chance of that happening because they literally can't do that. Ryan Carr says, was this all a PSYOP boost to boost Corinne's social media? I'm going to go with no, but hilarious question. Pippa May says, what are your thoughts on the chance of a hung jury? It's definitely possible. It's definitely viable. The ultimate hope at all the end of this is that the evidence is in and of itself, or the videos, which is the only real objective piece of evidence we have, because everything else is testimony, which necessarily has some subjective elements to it, that the videos are so good, so clear, that despite the defenses, many missteps, I mean, the videos are part of the evidence record, so the jury can consider them. So the last ditch hope is, no matter how bad the defense screws this up, the jury looks at the videos and says, well, that's clearly self-defense, and just ignores basically the defense being an utter buffoon. So that's a possible outcome. I wouldn't necessarily bank on it, though. What percentage do you give for not guilty counts? At this point, it is not going well. At this point, which it's obviously subject to massive change, but Lord, I'm hesitant to give a percentage at all, but it's really bad. I mean, if the trial ended right now, today, what's my probability on a not guilty verdict, on a straight not guilty? Christ, how close can I get to zero without it being zero? It's pretty bad. 10%? The hope beyond hope? Basically, the jury ignores all the stuff about the story and so laser focuses on the video that they overcome all that? 10%? If the trial ended right now? Yeah. Joseph says, help me understand how those leading questions get through the defense and the judge. It's the defense's job to raise the objection. It has been known to happen with a particularly new and green defense lawyer that the judge will help them out. And incidentally, at parts of this, the judge has been helping the defense out. At parts of this, the judge has absolutely been doing the defense's job. It hasn't been overly much. It hasn't been blatant. But there are definitely points of this thing when the judge has been doing the defense's job. So that should probably be a clue in and of itself how bad it's going. How bad does it have to be going for the judge to start doing the defense's job? Pretty damn bad. Especially for a judge who has 50 years of experience and has been on the bench for, 30? How bad does it have to be? Really bad. It's really bad. So, is there corruption? I don't know. The judge is not corrupt for not raising the issue himself. It's up to the defense lawyers to raise the issue or not, because as I pointed out earlier, there is a tactical element to it. Whether or not to raise the objection has tactical considerations. It's not a black and white thing. There are reasons not to raise the objection. So the judge forcing the objection would in 99.9% of cases be a misstep by the judge. because the judge is forcing an objection which has consequences, so they shouldn't do that. So there's nothing wrong the judge is doing by not raising the issue. There's a lot potentially wrong with the defense not doing it. I don't know if there's corruption or the lawyers are bad, but yeah. Random NPC said, but they did do that, but I don't know what I referred to because we moved on. Red QWERT said, the trial isn't being close to over yet. Wow, is Kyle screwed? It's a projection. It's a projection. It's a projection. How likely is he continued to be screwed throughout the remainder of the prosecution's case? How likely is it that they're going to be able to salvage this all during the defense's lives? It's a projection. If we get to day one or I can't imagine. It would be honestly bewildering to me at this point if somehow, while the prosecution's case is somehow still ongoing, we revise our doom prediction. I don't see that happening. I see it only getting worse from here. I don't see it getting any better. If it gets better at all, let alone significantly enough better for me to make a point of it, I'll be amazed before the prosecution rests its case. When the defense starts this case, we'll see. So maybe it will be the case that their directs will be so good and so brilliant that we will re-inchristen ourselves with the hope and the dream that is now founded on actual evidence. You know, at this point, I'm basing things on the evidence and where it suggests we're going and likelihoods. So if the defense manages to be a brilliant direct examiner, maybe we will post a video that says, Kyle Rittenhouse trial day, 15, hope restored. We'll see. What's the experience of the defense lawyer? I don't know. This is heading towards the judge declaring a mistrial. Yes? No, I don't think so. The only way that there's going to be a mistrial at this point is if the jury is hung on one or more verdicts. But I wouldn't necessarily bank on that happening. Watching You Daily says, do you think Richard's not objecting to the video that had militia in the grounds is grounds for ineffective assistance of counsel? Well, yes, but the question you're really asking me, is it sufficient? I think the question you're asking me, is it sufficient? Again, probably not. The standards for ineffective assistance of counsel are pretty high in a criminal case. They're pretty high. You're entitled to a lawyer, not necessarily a good lawyer. So if the lawyer is just bad, that's not ineffective assistance of counsel. It's ineffective assistance of counsel when they, as I was saying before, these are some examples. They negligently failed to follow up on some exonerating evidence. They negligently failed to, interview people, witnesses, obvious witnesses that could have helped their case. They negligently failed to even explore what appear to be viable lines of defense. They fall asleep during the trial. They are drunk during the trial. Those are the kinds of things you're looking for. It's a pretty high bar. Is this a thing that helps with it? Sure. Does it get you there in isolation? No. With the other things we've seen so far, does it get you there? Probably not, but we're heading along the way. So I guess continue hoping we'll cross that line. But as I point out, it's a really, really high bar. So I wouldn't be banking on it. Alexander Harper says, I was mistaken at the end of the day. The prosecution's objected to the video he already shown the jury. It's the motion that are discussing first thing tomorrow. Yeah, I think that's correct. Provolone Loaf says, that is how close the zero line is sad. It's funny. I hope he can turn around. Yeah, it's like if it ended today. Fortunately, it doesn't end today. So, yeah. Ryan Carr says, okay, real question. Is this what the next potential week and a half looks like of the trial? Or is there another phase that needs to happen? I don't know how long the prosecution's case will take. The prosecution's case is when they are still calling witnesses. So the defense can't call any witnesses until the prosecution stops calling witnesses. So the prosecution has to ask all of its witnesses to the stand first. And then, at that point, the defense can choose whether or not to call witnesses, which one can only hope they will do. Although it's not necessary in every case. Though there are definitely situations when you don't have to call witnesses because the prosecution's case sucks. That can be a thing. That's not this thing. So, Yeah, it can. That would be, I guess, it's not technically speaking another phase because it's still the trial, but it's, for the purpose of your question, it's a different phase. So things can change when the defense is starting to call witnesses and they're on direct. Maybe they can pull this all together. We'll see. Scorpion 142 said, unrelated, but at what point did the judge say this case is so fudged? There's no case for a defendant to get a fair or just trial. Unfortunately, he is getting a fair or just trial. To have a fair trial means that the defense has the ability to put on their case, right? Nothing is stopping the defense from putting on their case, except there is a bit of a Brady issue with the FUBAR video, although it's unclear. I don't think that ultimately goes anywhere because there's so much, because the problem, by the way, in that case is, so you assume with the FUBAR video from the FBI that that piece of evidence gets thrown out by the Court of Appeals, let's say, on a Brady motion. It wasn't disclosed to the defense. Then the next question is, okay, if they didn't have that evidence, would they still be able to get to the verdict they did? The answer to the question is yes. It has to be yes. It's not like that's the linchpin of the whole thing. It certainly helps with the argument that Rittenhouse was chasing him, but you don't need that to draw that conclusion. There's other video that would allow you, other witnesses that would allow you to draw that conclusion, I'm sure. So he is getting a fair trial. It's just that the defense so far is not taking advantage of it. Ken's counseling couch, hypothetically buried half a dozen bodies in Texas today. Ready to give the worst defense if said hypothetical is true? How could you make my case worse than Rittenhouse's at this point? Within the bounds of attorney's ethics? Well, I don't know that I can because I'm ethically... I don't know that I can, actually, because I'm ethically bound to put on I have to zealously represent you. You are the client. You get to state the objective. So if you come to me and say not guilty, I am ethically obligated to try to put on the best possible case I can. So I can't throw it because that would be a violation of my ethical duties. It may not be a violation of this attorney's ethical duties because maybe he can't put on a better case. You're required to put on the best case you can. Maybe this is the best case he can put on for him, which is lame. But maybe that's where we are. So I can't make it worse than Rittenhouse because I'm ethically not allowed to. Sorry. If you want a worse defense, you have to hire someone else. Mike Hurley says, can you give an example where not objecting is a strategy, a type of you open the door thing? I mentioned this a little bit earlier. When you object, it comes with a cost. The cost is you are denying the jury the ability to hear the answer. The juries want to hear what's happening, right? They want to hear what the witnesses have to say. When you object and you win, you're preventing the jury from hearing the thing. You are interfering with the jury who wants to hear the thing. So there is a negative cost to that. So it's a question of, is the juice worth the squeeze? Is it worth what you're getting out of it to object? So if it's a minor issue and it doesn't really hurt you that much, you let it slide. You have to be considerate. If you're objecting all the time, the jury is much more likely to see you as just obstinate and jerkish rather than as an advocate. So you have to be, because credibility is a lot to the jury, maybe everything to the jury. Credibility is everything. So if you just come off as obstinate and jerkish, even though you're technically legally right, you have a chance of poisoning yourself with the jury. So you would be ill-advised unless there's very few things that you could object to. So if there's only a few things that are in principle objectable, then maybe you can object to them all because it won't hurt you. But that's probably not most cases, and it's definitely not this case. So you would be ill-advised to object to everything because you're putting your credibility on the line and making the jury sad. Curtis says, I suspect the prosecutor is going to try to claim that because the slings Kyle's had the women, he'd actually fear it's going to be taken from him. I'm not sure that legally matters, but because once the hands is on the gun as Barnes pointed out, that could be viewed as being armed. The mere fact that they were touching the gun could be viewed as being armed. So I'm not sure that gets you to where you want to be, but it doesn't hurt. Joseph says, so the defense should bring R&R and his video breakdown into court. I haven't seen R&R's video breakdown, but R&R probably it cannot be doing any worse than this. So probably. Jake Lyons says, what are your thoughts on the autonomous zones within the association? What's your thought on autonomous zones with association with the prosecutors? I don't know about what you're saying, so I can't give any thoughts to the specific situation. I'm not going to comment on something I don't specifically know about. I will say in general, I don't approve of autonomous zones because, you know, they're supposed to, that's contrary to the rule of law. So without commenting on these specific prosecutors and whatever association they may or may not have, I generally oppose. Our Red Qwerty says, sounds like Kyle's only hope is for Johnny Cochran to come back from the dead and start being Kyle's defense lawyer. That would help. Sliding Edge says, Mark Richards has more than 30 years experience doing criminal defense law in Wisconsin. Early in his career, worked for 2 years as assistant prosecutor. Well, I'm not sure what he learned during those 30 years, but I'm not seeing it reflected right now. And Not Atheist says, I just joined the live stream. Are you able to summarize what you said so far? Yes, I'll give the same summary I did earlier. We are one step away from Kyle Rittenhouse being dragged outside behind the courthouse and being shot. That's how bad, by the bailiff. You know, we're one step away from the judge ordering him to be taken out and shot behind the courtroom. Obviously, that's metaphorical, not literal, but you get my point. President-elect Austin M. says, you may have spoken on this, but is it possible that Richards is letting the state paint themselves into a specific narrative, then hitting hard on the facts? He's won like that more than once. I don't, maybe, you know, I mean, there has been a suggestion that I'm wrong about all this, because this is the kind of thinking that comes from big city law. This is the kind of thinking that would come from a New York lawyer or other big city lawyer, and I can't deny that that's been mostly my experiences. So, and in Countryville over here, that's not how juries work. And so it's been suggested that this prosecutor is speaking the way that these jurors would understand, and I just don't understand it, which I guess must necessarily be possible. I'm not these jurors. I'm definitely not part of that community. So maybe it's the case that although this looks foreign and strange to me, I'm confused by your ways, that to the reasonable juror in Kenosha, this looks like the best lawyering they've ever seen. I hope that's true, but I have no way of knowing that because I'm not that. I can't project myself into that. So all I can tell you is my view. So maybe it's true that the jury is eating up everything he's saying and he's actually doing way, way, way better than I'm giving him credit for. Maybe it's like 90-10 the other way. Maybe the jury is so swooned by his factual recitations that they're one step away from leading him outside the court door to give him a parade in this analogy. I don't see it, but I can't see it, but okay. Not the atheist says Kyle winning or losing, so cryptic. It's horrible. He's losing badly. The judge will save it. Very, very doubtful. Very, very doubtful. The judge has no cause to save it. And I've said this before, and I'll say it again. It's like, you know, one of the things I do on my channel is I try to put myself into the posture of a judge. That's one of the things I try to do on this channel. So I can give you my opinion, which I've done in this case. I don't always give my opinion. In fact, mostly speaking, it's somewhat rare on my channel for me to give you my opinion. Mostly I don't do that. But I'll give you my opinion because I have a strong opinion in this case, which is Kyle Rittenhouse didn't do nothing wrong. That's my opinion. Now, if I were the judge in this case, I have to, as the judge, follow my oath. I have to follow my oath of office and give neutral and fair treatment to all those before me. So, would I, as your hypothetical judge in this scenario, would I save this all by refusing to enter the guilty verdict? And the answer is no, I would not. The law simply does not allow me to do that. I have to put my personal feelings aside. The jury, unfortunately, based on what is known at this point, can come to the conclusion of guilt. It's not necessarily the most, if you're like basing it on probability, or well, probability is the wrong word. If you're basing it on, I don't know how else to put it. If you're putting it on, I guess, probability. If you're putting on the probability of a jury being able to reach that conclusion reasonably, it might be relatively low, although I don't think it's that low at this point because of how bad the prosecution's or defense is doing. But it may be somewhat unlikely. But the question is likeliness of reaching likeliness is still the wrong word. It's totally the wrong word. Can a reasonable jury, based on the presentation of the evidence, come to the conclusion of guilt beyond a reasonable doubt? That is the question. Much better phrased. Can they do it? Not should they do it? Not is it the only conclusion they could come to? The jury can possibly come to many different conclusions. This is possible. So the question for the judge is and must be, can the jury come to this conclusion? And the way you ask that question is by saying, is the weight of the evidence so overwhelming for the defense that the jury would be unreasonable in disbelieving the quantity of evidence that's available for the defense? It's like, yes, there is a technical win that's possible in the defense. Impossible. But it's so hard to find, and the jury would have to disregard so much evidence to the contrary that no reasonable jury could get there. You'd be blatantly unreasonable for ignoring all this stuff. That's kind of what the judge has to do. Are we there? Not even fucking close. That's how bad it's going. So I don't expect this judge to save him. I wouldn't save him. I think Kyle Rittenhouse didn't do nothing wrong. That is my opinion. Nevertheless, as a judge, I can't always rule the way I want. As Scalia said, a good judge cannot always reach the decision they want to. I think Kyle Rittenhouse should go free. I think Kyle Rittenhouse is not guilty and innocent. But if a jury came back with guilty, I, as your judge, very begrudgingly would have no choice but to send him to jail forever. So, sucks to be me, but that's the law. So, I have to. Wisconsin accent is the one switching TH and D in the words. Richard sounds like an idiot. I'm from small town Wisconsin. Noted. Dog, planes, and cars and neat stuff. Would it be bad defense to show a video of how a bullet went in their back as a fluke? No, it wouldn't necessarily be a bad defense strategy. Then showing the deceptive nature of the DA. It's not necessarily showing the deceptive nature of the DA. It's rather showing that your interpretation is the much more plausible one. That's really what it is. I don't think it's fair to say the prosecution has been deceptive in any sort of technical sense. They are within the bounds of their ethics. They have promoted a theory that is a reasonable interpretation of the evidence. It, again, doesn't have to be the most likely. It just has to be a reasonable interpretation. And they're there. It is a reasonable interpretation. What the defense has to do is show them a much better, more likely reasonable interpretation to win. So you don't necessarily have to go to deceptive, nor do I think you're there on a technical level. President-elect Austin said, if Richard and his partner, Jeff Bezos, can win on cross, then roll it in calling up Dr. Black tomorrow, then drag it out for 5-6 hours just analyzing the video may be a win. I don't know what that's supposed to mean, so I missed it. Cody says, I've always been intimidated by the thought of law school, but if Kyle's lawyer can do it and still be a lawyer, I'm starting to like my chances. I'm not necessarily sure Kyle's lawyer should be your inspiration on this one. Graham's Bar says, would it be against the rule for defense to label the video justice served to a pedo? Yes, it would. The reason it is because Kyle Rittenhouse can only rely on the things he knew. And he had a lot of things that he knew that helped his case, but he has no way to know this guy is a pedo. So you can't label it a pedo. So that would be wrong. It'd be, why do I think Kyle's so innocent? It's a question of law, right? It's a question of the videos. I've stepped through this analysis in more detail in prior videos, but on my prior streams in the preliminaries before the case happened, I stepped through the videos, and I've stepped through the videos with other lawyers and looked through it step by step on a question of self-defense. Like, is the self-defense the right legal argument? And looking at all the factors in the videos, which was all I had at the point, I was like, yeah, it's self-defense, clean. And that was the conclusion that basically all the lawyers I talked to came to. It was like, when we analyze those videos, it's clean. He armed himself, yes, and intentionally put himself in harm's way and wound up killing himself. But arming himself and intentionally putting himself in harm's way is not, putting yourself in harm's way is not illegal. Literally everyone who was there that night was in harm's way because the violent situation was applied to everyone. So the fact he put himself in harm's way is no different than literally everyone else who was there that night. Everyone else that night was putting themselves in harm's way. It's not a unique issue for Kyle. Similar with being armed. He was not the only person being armed. Lots of people were armed. Also, it's legal to be armed. There's a question of whether or not it was legal for him to be armed, strictly speaking, although I think it is. But also that doesn't impact the self-defense analysis, incidentally, on technical legal level. So even if you think that he's guilty of the gun possession charge, which seems to be a viable possibility, I guess, that fact, even if you assume it to be true, does not impact the self-defense analysis. Even if he is in fact in illegal possession of the gun, it does not preclude him from using it in self-defense. Nor does it impact the self-defense analysis. Of course, it doesn't impact the possession charge either. We discussed this more in depth. But yeah. President-elect Austin says, it means they have to use Dr. Black, an expert witness, to discredit the cyber cop who Binger objected to being an expert before recess. That's one of the last things the jury saw. Well, if they're able to use Dr. Black effectively on direct, along with other people on direct, then maybe hope will be restored. Harm's way, not arm's way. Maybe it's a pronunciation difference, but harm's way versus arm's way. I've heard it both ways. I'm not sure if one is strictly speaking more correct. Maybe I could look up in the dictionary, but Grimm's Bar says the 2 casings from extra shots were found to be Arugula 223 RAM. The third shooter could have shot Rosenbaum for the 4th entry wound. First shots hit the concrete, splash and IR. That would be a viable, well, not necessarily, because the ballistics might be able to tell the difference. Assuming that there are ballistics that would uniquely identify the rounds, which is not necessarily true in rifle rounds, depending on what happens once they enter the body. So if there was enough left of the bullets to produce a unique ballistics, it may be determinable for fact that it was Kyle's gun. If it's not determinable, in fact, from the ballistics, then you could argue that to the contrary if you were so inclined. Scorpion said, Nick Rikita, in rebuttal, because he made a decision that Kyle made earlier that day, then he should just die. I'm not sure what Nick was necessarily referring to, but I'm sure he had a salient point. Joseph said, medic, I am an EMT. Anyone against medical? Medical? Oh yeah, carry a gun. Total terrorist? No. There to pick a fight? How? I didn't say any of those things. I definitely didn't say he was a terrorist. I definitely didn't say he was there to pick a fight. Didn't make any of those arguments. So I'm not sure where that's coming from. But based on what the jury is hearing and the judge is hearing, things are not going well. So, is possession of a weapon illegally implied criminal intent? Not with respect to the murder charge, no. No, the intent for the murder charge is the intent to kill. The intent to possess an illegal weapon is an intent to possess an illegal weapon. To state it as a tautology. It's nothing else other than that. It has nothing to do with the intent to murder. Presumably, whether or not you have an illegal weapon or not does not really speak to your intent of what you're going to do with that firearm in particular. So, no. Now, other evidence may indicate the intent. So, it's not like you can never determine it. But in isolation, you can't. Because, like, well, you know, it could be a lot of things. They can check the casings. I'm not sure how that does anything for you to check the casings. If you can determine the casings are from different guns, great. But how does that get you to whether the bullet came from one gun or the other? It doesn't. Checking the casings, I don't see how that helps. The question would be the ballistics of the round. The fact that other casings are there means it's possible the round from the other gun hit Kyle. So if there are no salvageable ballistics, then great. But if there are salvageable ballistics, the salvageable ballistics win. So, yeah. Prosecution in the open said Rosenbaum was chased and have not proved that at all. Excuse me. Excuse me. Excuse me. Okay. Did the prosecution prove it? When you're asking a question like, did the prosecution prove that Kyle chased Rittenhouse? What you're asking, really, and this is consistent with what I said before, what you're really asking is there evidence available from which a reasonable juror could draw the reasonable conclusion that Kyle is chasing Rittenhouse? So when we say prove it, that's what we mean. Could a reasonable juror, from the evidence that's available, draw that reasonable conclusion to beyond a reasonable doubt? And the answer to that question is yes, because of the Fleur video. And if not the Fleur video, I think other video shows it as well. But the Fleur video definitely showed it critically. But if it's not admissible, I think it's also shown in other evidence. What you did see is you saw Rosenbaum running in a direction, and you saw Rittenhouse behind him running in the same direction. So they were both running in the same direction at the same time with Rosenbaum in front. That is the objective reality. So is a reasonable conclusion, not the only reasonable conclusion, not the most reasonable conclusion, but is a reasonable conclusion for a reasonable jury? Is it a reasonable conclusion to conclude that because Kyle was in behind, running in the same direction, therefore he was chasing him? And the answer is yes. Now, there's a whole bunch of other possible explanations, and I shouldn't have to convince you of that. So the defense's job is to show this is not the most reasonable interpretation. Here's a much more reasonable interpretation, which up to this point they have not done. But based on what they have so far, the jury could conclude it. It is within the bounds of a reasonable person's inferences to draw. So, fun. Yeah, Rosenbaum and Rittenhouse. If I said it backwards, then you'll forgive me. Internet Commentator says you have 659 people watching you right now. I think it's a record. Outside of some very specialized streams, it is pretty, I think it might be a record. We've crossed that before with some specialized streams, but this is pretty high for my channel. So to the 659 of you who are out there listening to this, I really do appreciate you being here. I'm trying to answer your questions as best as you can. I'm very sorry to my right-wing friends and my conservative friends, of which I consider myself a part, that I can't give you better news, but I have to be an honest broker to you. And I may be wrong. I'm not God. I'm only one person giving you a perspective, but this is my perspective. It's somewhat reasonably informed from both a legal perspective, trial advocacy perspective, watching the evidence perspective. So it's, but it's what I think. And maybe it will turn out that, what I thought was way off what the jury thought. And I don't understand the people of Kenosha. So that could happen, I guess. But thank you to the 659 of you who are here. I really appreciate it. I really appreciate it. And if you want to subscribe, and you haven't subscribed already, 667 of you, incidentally. If you have not subscribed, why not please hit the subscribe button? I would very much like for all 667 of you to subscribe. That would be great. At least Kyle can get off so long as one juror says he's innocent. Well, strictly speaking, it's not him getting off. It would be a mistrial, which isn't technically the same thing because the prosecution can try again. So as long as one juror votes not guilty, he's not guilty. Well, yeah, he's not guilty for the moment, but he can be retried, and you would imagine the prosecutor will retry. And one can only hope in that instance that they get better attorneys so that the defense can win the day. But yeah, if they I mean, it's true. They only need one to win this particular trial. They need all 12 to never have a trial again, which seems unlikely as hell. But yeah, you always have the prospect that you'll have one. Could happen. I mean, that's one of the saving graces for the defense. It's like, I only need one to win this round. This is true. Very fair point. SS says, wait until the defense makes his case. We'll see, but it only takes one juror. But I don't see getting anyone taking a stand. Yeah, SS, I don't know if you've missed this at all in my chat, but I've said as much several times. I've said several times that I don't see the analysis changing fundamentally as long as the state is calling witnesses. But we can hope, although we have no evidence really to draw this conclusion, but we can hope that that when he takes over, that we'll be able to come on, say, day one or day two and be like, well, fortunes have changed dramatically and now we can all have hope again. Andrew says, yeah, Atlas Press says your analysis is in line with most lawyers' what I've said today. Yeah, it's in line. There is a disagreement of opinion about just how black-pilled we should be. So some have more hope than others. I might be more on the black-pilled side, but we're definitely all black-pilled to varying degrees of black-pilled. It's not going well. Thus far was the defense's single biggest mistake in representing Kyle. In my humble opinion, their biggest single mistake is not being good storytellers, which is also what Barnes said, which is also what a lot of people have said. The fact that the defense does not have a cohesive narrative, the fact that they're not able to cohesively frame the facts in a story or a narrative that drives the jury to its end conclusion is, for me, the biggest single mistake. Yeah, that is the biggest single mistake, is they completely have failed utterly. They failed utterly up to this point to have any sort of narrative coherence, either overall or within the context of any particular witness. It's been a mess. How is it, despite the video being clear as people do, especially left-wingers, think Kyle's guilty? I don't know the answer to that question, but I've told you how the jury can get there because it's not helping. Hey, Uncivil, did you cover what was up with the prosecution objecting to the video he already showed the jury? I think there was a dispute over whether it was admitted into evidence. I think the defense might have been admitting it to evidence or something. I don't fully understand the issue, and I understand it's going to be argued about more tomorrow. Assuming it was properly preserved, which seems to be at least tenable. Any idea how experienced the defense is? They seem like out of law school. Apparently, it's 30 years. Uncivil Law and Barnes agree. Oh my God, clutch my pearls. Yeah, I mean, the guy sucks at storytelling. Barnes says he sucks at storytelling. I say he sucks at storytelling. Barnes agrees that storytelling is important. I agree that storytelling is important. So we don't disagree on that. Incidentally, and this will probably surprise literally everyone on the chat. You ready for this one? You ready for a surprise? I don't know if I should tell you this or not. Maybe I shouldn't tell you, in case it happens, and then it'll be even more surprise. Maybe I'll keep it in reserve. No, you're not going to learn about it today. Ha ha ha. Can they do an appeal? Yes. Are there any appealable grounds? Not really, except for the legal one on the gun possession is an appealable ground. But is there any other ground Well, there's the Brady violation, but it unfortunately doesn't get you anywhere in the end, because even if you win, there's so much other evidence, it doesn't get you to where you want to be. So you can appeal on the Brady violation, it just doesn't matter in the end. You can appeal on the weapons possession charge, and that's winnable, but it doesn't really matter if you're already serving life in a practical sense. Is there any other grounds of appeal that I've noticed so far? No. So I don't see any viable appeal options at this time. Shout out to Uncivil Law. I got kicked out of chat once before, so hush up, but good stuff. Just be nice to sell that stuff. How much will that cost an appeal? It could be quite expensive. The fact he went there armed is evil and wrong, in my opinion. That is the same as guilty. It's definitely not the same thing as guilty, and I appreciate you distinguishing the difference. Evil and wrong is a moral judgment. I disagree with you on the moral judgment, but I appreciate that you distinguish the moral and legal, which I do on this channel literally all the time. Sometimes to the chagrin of my own channel. Speaking as a Midwesterner, the prosecution's witness seemed unconvincing and disingenuous in a way, mostly a social media guy. Lord have mercy, do I agree with you. God, Lord have mercy, do I agree with you so fucking much. Christ. That social media witness, oh my God. Why? For the love of God, why? And why did it go on for 6 hours? Holy shit. Why was this guy here? Robert Barnes is of the opinion that he was called to bore the jury and make them hate watching video evidence. But I don't know that that's correct, because presumably that would swing both ways. And the problem with Barnes's theory, which kind of makes sense, is that if his motivation is to show these long, rambling, incoherent videos for the purpose of making the jury not want to watch video evidence ever again, the problem for that is the prosecution has video evidence that at least assists their case. And they want them to pay attention to that, and they can't have it both ways. So they can't have the jury paying attention and not paying attention, right? So that doesn't seem to be right. So I for the love of my God, I cannot begin to fathom why they called this guy. He had nothing of value to say at all. He was a horrible, horrible witness. He was completely unsure of himself. I'm not sure that he actually testified as to a fact, because he kept saying, I don't know, I don't think, I believe, I'm not sure. He undermined himself 8 ways from Sunday. He was a horrible, horrible, horrible witness. Horrible witness for the prosecution. Horrible witness. It was definitely the prosecution's biggest misstep to date. I could not agree with you more. Why? Why for the love of God? I think I lost the will to live at several points in the video. What is the particular evidence prosecution has reasonably established against Kyle, and how would you rebut? Oh, the prosecution has the prima facie case, no problem. There's the affirmative defense, right? They have the prima facie case without blinking an eye. As to the affirmative defense, they have some plausible ideas. Their biggest plausible idea, which doesn't really work if the defense counters it, but the defense has not done a good job countering it up to this point, but maybe they will later. But their biggest thing going for them about why, and it seems to be the reason why they were doing what they were doing on the prosecution side, is because the situation was volatile to everyone, because everyone, not literally, but the collective everyone, had rocks being thrown at them and tear gas being thrown at them and dumpsters pushed in their direction and angry words and some violence. And, you know, this was the collective experience of the entire soup, right? The idea was because everyone was having this experience, therefore, and also because no one else used their firearm in self-defense, this seems to be correct, right? So, because everyone else was in the same situation, because no one else used their self-defense, therefore, because no one else did it, it must necessarily follow that it's objectively unreasonable for Kyle Rittenhouse to do it. Now, the counter to that is relatively easy in principle for the defense, right? Because what the prosecutor just basically said in so many words is look at the trees. The counter is pretty easy in principle. Look at the forest. The prosecution's argument is look at the forest. The counter is look at the tree. Look at the specific situation that Kyle's in. Yes, everyone had vaguely the same background, but his situation is unique for these particular reasons, which are fair. He's in a different posture than him. So the counter from the defense is there to be made. It hasn't been made yet, but so the prosecution has given the idea because it's true of everyone else, it must be true of him, and be like, oh, that seems like it could flow. Which, if you're not trained in formal logic, yeah, probably. So so until the defense really brings out the stop looking at the forest, look at the tree, you idiots idea, it's the prosecution's where they need to be. They have made their prima facie case, and they have made it possible for them not to find the affirmative defense beyond a reasonable doubt. Because, yeah, that's where we're going right now. No one else was in the same situation. Yeah, that's what the defense's argument should be. We just haven't gone there yet. So hopefully that will happen at some point. I don't think that's how the analogy works, but you figured it out in some way. Okay, well, fair enough. The prosecution's argument isn't look at the forest. It's look at the irrelevant pebble over there, therefore it isn't a forest. I'll take your word for it. I liked my analogy better, but maybe it was confusing. What other questions can I answer for you about the Kyle Rittenhouse trial and how well it's going for Kyle? I think I've probably said everything I need to say, but I do have 659 people here, so I have a little bit more energy, so I thought I'd give them a bit of a answer. So if there's anything else, I'll answer it, and if not, then I'll kill the stream and we'll move on with our lives until another day. Was Kyle expected to speak in his defense? Yes, that seems to be what the defense lawyers are saying. It seems like a bad idea. It is essentially impossible for Kyle to testify without the prosecution being able to drag out at least one statement, and realistically, much more than one statement that in isolation will be damning for Kyle. It is basically impossible. Kyle can't pull it off. No one can pull it off. It's basically the same thing as why you don't talk to the police. Do you really think you can talk to the police and not say anything that can be understood as damning? Good luck, my friend. Don't try. It's not going to end well. It's you versus a professional who's been doing this a while, has some experience, and you have no experience. It's like you going up against the equivalent of an NFL athlete when you basically have never even played football. In this analogy, like, they're a professional that's well trained and has lots of experience. You've never been in this situation, have no experience. I'm going to go toe to toe with the police / the lawyer, and I'm not going to say anything that can be against me. I'm just going to make my case as great as possible, and it's going to go all super well for me. Sure it is. Yeah. Would this be allowed? As an armed person, if someone tried to take your gun as a violent manner, how would you react? Yes, that would have been a valid question. I think Barnes raised this issue, or someone else did. Yes, or no, I don't think it was Barnes. It was Legal Mindset, I think, who raised the issue. But yeah, he pointed this out. It's like, you could have asked the police, hey, by the way, if someone put a hand on your gun, how would you react to that? Yeah, we didn't ask those questions, though, so it doesn't matter either way. I asked twice about what constitutes justified use of force in Wisconsin on civil law. I'm sorry I missed your question. There's a fair amount of chats. I didn't mean to ignore you. I'm sorry. What constitutes justified use of force in Wisconsin is basically the same thing that constitutes justified use of force everywhere. You have to have both an objective and subjective belief. So that means you personally have to believe it, and also a reasonable person would believe it. You have to have both of those. That there is either ongoing or imminent threat to death or grievous bodily harm. So you need either ongoing or imminent death or grievous bodily harm. This should not be this challenging for the defense. Does Kyle have the subjective belief? This seems very clear based on what we know. So he's there on subjective, but does he have the objective belief? Or no, I'm sorry, that's the wrong way of phrasing that question completely. I'm sorry. Would a reasonable person have the objective belief? Would another person of ordinary prudence, which as a practical matter means the jury? That's as a practical matter who that means. Would the jury, if they were him, do the same thing? And that's the standard. Now, this shouldn't be too hard for the defense to get there, but so far, not so much. So it's not going well. Why the cops wave him by when a gun's strapped to him? I don't know. Also, it doesn't impact the legal analysis because he's not being charged with, resisting arrest or fleeing from the scene or anything like that. So why the police do that? Don't know, don't care. It's not relevant to any of the charges that are before us. Apologize. President-elect Austin M. said, look up Mark Richards plus Kyle Bears. Richards is going to try to play an emotional call to his favor, which is also certainly mission failure. Yeah. Nate the Lawyer's in the house. Hello, Nate the Lawyer. I was blackpilling the world with my 627 members. I didn't even see you join, but nice for you to be here. Eric Sandbrook says, putting Kyle on the stand is a bad idea. I get that. Does it seem potentially catastrophic given the different level of skill between prosecutors and defense? Yes. It seems potentially catastrophic. The problem is you don't need him to get all the upside of him testifying. There's no necessity to him testifying. You can get everything he would testify to from somebody else. You don't need him to testify to anything. You can get it from somewhere else. So you should get it from somewhere else. And then it's all downside from there. If he was the only person that could provide a key piece of evidence, then that's a counter consideration, but you're not there. He can authoritatively testify as to his subjective mental state, but the prosecution's going to twist that to hell, so it doesn't really help. Do I think the judge has been fair in his rulings on objections so far? Yes. I disagree with the judge's ruling on the possession charge, but overall he's been very fair. He seems like a very fair judge. Yeah, you can get all the upside from the video snippets. This is basically correct. Yeah, you can get all the upside. You don't need Kyle. You can get all the upside you need from somewhere else. The prosecutor got hands on a transcript. The prosecutor that has a transcript is not surprising. The defense should be able to get transcripts as well. That isn't surprising. How does this case compare with the Michael Dietra case in Florida about the handicap spot shooting? Is that the case outside the convenience store where the guy was basically trolling to shoot somebody outside a convenience store? If that's the case I was thinking of, I don't really see an immediate comparison because I don't see the provocation that was present in this case. Apologize, I should say the other way around. I don't see the provocation that was present in that case, in this case. The use of force expert will be golden? Hopefully. And the judge is better defense lawyers than Kyle's lawyers. Yeah, this is very true. All right, I'm going to sign off for now because I think we've been pretty thorough and I'm a little tired, but I've tried to give you a good, and for the 629 of you, again, thank you very, very much. This is a very high watermark for my channel. It really feels like I'm making some positive steps in my growth and doing something right. Excellent. So I really appreciate all you who are here. Please remember to subscribe, like, hit the bell, all that good stuff before you leave. I'd really appreciate it, and I'll continue to do my best to give you the truth as best as I can. So I hope all that's helpful. Until later, my friends, I hope all is well. Cheers and goodbye.